and power. I stand here with the backdrop behind me of the city of Dallas, an amazing, beautiful skyline. And most skylines in the city are there to represent and project an image of a city, that of prosperity, promise, and progress. But here in the city of Dallas, when we go from the backdrop, the skyline up high, and we go down low into the streets in many Black communities and communities of color, prosperity, promise, and progress eludes many of us. And so we want to talk about the ways in which we can get engaged and have action, activism, and advocacy to change that. So one of the things we have to do is we come down into the streets is radically reimagine public safety, because one of the things that we have to deal with oftentimes in our Black and minority communities is police violence, state-sanctioned violence. This form of physical violence is so traumatic that we see play out on TV almost every other day here in America, and right here in Dallas, Texas. You know, we think about and remember Botham Jean. We think about Atiana Jefferson in Fort Worth, Texas. We still think about Breonna Taylor in Louisville, Kentucky, and we think about George Floyd in Minneapolis, Minnesota. So for many of us, we have to make sure that we stay in this struggle for justice, and liberation. We have to make sure that we stay in this struggle against state-sanctioned violence. So we have to make sure that we are part of a movement to bring about a more positive way of policing our community. So as we just talked about the forms of physical violence that many of our communities are up against and feel the brunt of by way of state-sanctioned murder, we also have to deal with the structural violence that takes place in places like this, Dallas City Hall, and many city halls around this country, state houses around this country, as well as the U.S. Congress. Public policy oftentimes is unleashed on our communities that wreaks havoc on our communities, and we have to deal with that as well. So we want to talk about some of the things that take place by way of public policy that we have to be aware of, that we have to educate ourselves on, so we can be better advocates and we can engage in activism to bring about a permanent change in our community so all of us can flourish and have access to life-giving, life-sustaining resources. So we left City Hall where we talked about where public policies are made that impact primarily Black and other communities of color, and we stand now here behind me what was Shingle Mountain, which was a toxic waste dump right here in the city that was right next door to Marsha Jackson's, literally her backyard. And so through activism, advocacy, and action, we were able to get those shingles removed, but the fight is still far from over because the city of Dallas still has racist zoning policies that impact many of the residents who live here in Floral Farms. And so while the shingles maybe have been removed, we have to make sure all the toxic waste has not seeped down into the land. And so for us, we want to make sure we continue to be involved in environmental justice work, because we want to make sure that all of us have access to fresh air and clean water. And this is just one of the many places in our part of town where we have toxic waste and toxic dumps that impacts the health of those that we love. And so as we continue to fight for justice in terms of environmental justice, another area that concerns us is economic justice. One of the things that proliferates our neighborhoods, particularly our Black neighborhoods, are payday loan and auto title loan stores where they charge such excessive interest rates and rollover fees that traps people into a cycle of debt. So we want to also make sure that we do our part to have right policies, public policies that make fair lending practices, so those that must go get small dollar loans can do so without being trapped into debt. So this is yet another policy issue that we have to be concerned about and engaged in. So we have talked about many issues that are taking place here in the city of Dallas, but it happens all across this country in many of our areas where Black and brown people live. And so now we conclude this tour of our city right here on this sacred ground, this ground where former enslaved African Americans founded this area of Dallas. And so for me, I remember and I think about all of their tenacity, their self-determination to make it in spite of what they found themselves up against by way of bad public policy. And so I think it's incumbent upon all of us to do our part to engage in this ongoing struggle for justice, peace, love, and liberation, because while we may deal with so many examples of material impoverishments in our communities, whether it's environmental racism, economic injustice, police brutality, and the list goes on and on, food justice, what we have to remember is that we still do not lack, that we still have all that we need to create a world in our communities that allows all of us to flourish, because we are not lacking and we don't have a deficit when it comes to our rich culture and our rich heritage. We don't lack when it comes to our innovation, our imagination, and we certainly do not lack in our belief in a God who cares about us, who loves us, and who wants to make sure that our lives between Sundays is still full and allows us to flourish and be all that God has called all of us to be. So we're asking you, will you join us, partner with us, and become a justice partner today?
Good afternoon, everyone, and welcome to today's event. My name is Carlos Fletcher, and I will be the moderator. Today's event is a legal session that will cover family matters, a look at key child custody issues. This program was designed to address the need for effective co-parenting, which has been heightened during the pandemic. So during the next 30 minutes, you will receive vital information that will assist you and your loved ones in navigating the court system, child protective services, and vital resources from organizations that is committed to strengthening the co-parenting relationship. This program was designed to address the need for effective co-parenting, which has been heightened during the pandemic. So I will introduce you our attorney speakers today. First up will be Kathy Rue. Attorney Kathy Rue is the founder of the law firm of Kathy Rue, a general civil law practice in Southlake, Texas. Ms. Rue has handled a number of family law cases throughout the North Texas and is knowledgeable in the areas of divorce and child custody. Attorney Rue has earned a reputation throughout the community for integrity and commitment to excellence. Ms. Rue is licensed in Texas and Louisiana and is a graduate of Louisiana State University Paul M. Herbert Law Center. She is a member of the State Board of Bar of Texas and the Dallas Bar Association. And so we will move on now with the opening prayer by Chloe Dawson, one of our faithful members. And I will turn it over to Chloe at this time.
Amen. Good afternoon, and thank you. Please prepare your hearts and minds as we go to God in prayer over families. Father, in the name of Jesus, how we thank you and praise you. Father, we come lifting up families today. We thank you for the information that we will be receiving, Lord God, to keep our families united. Father, I pray that you would keep families united in love for you, united in love for one another, Lord God, in the name of Jesus. We pray for your healing. We pray for your restoration over families, Father, in the name of Jesus. Now, Father, I ask the information that has been given unto your people, that we will be good stewards of it, Lord God, in the name of Jesus. So we thank you for this time. We thank you for a faith, a love, and a hope over your families. In Jesus' name, amen.
Amen. Now please welcome Attorney Kathy Rue.
Good morning. Thank you, Ms. Dawson, for that beautiful prayer. Thank you for lifting us up this morning in prayer, and I hope that all the attendees, if you get anything out of my presentation, please make sure to give your glory to God, not to me, because he is working through me to minister to you today. This has been a challenge getting to this point with the presentation, so all glory to God. I'm going to talk to you today about custody issues and the state of Texas and what the law says, and give you a general idea of how custody issues work. And it's important that if you have a legal custody issue in the state of Texas, it's really, really important for you to educate yourself and get as much knowledge as you can about what the law says. And you can start by reading chapter 153 of the Texas Family Code, because that is the chapter that has all of the statutes, all of the Texas statutes that govern custody issues, modifying custody, enforcing custody, and obtaining custody. And it also has the law on what the roles of each parent is when you're dealing with custody issues. So it's really, really important that you educate yourself. For me, I like my clients to know what the law is, and I try to educate them when they come to me, because I firmly believe that a client who knows, who has knowledge, is not necessarily easier, but they work better with me. We're a better team when they have a lot of knowledge about what the law says. And then they can help me develop their case, because they know, because they know what facts are going to be important, and they can help me develop the facts of their case. So to start off, let's talk about the public policy in Texas, because this is going to be the framework of the whole custody system in Texas. And so Texas's public policy regarding custody and regarding children is to assure that children will have frequent and continuing contact with parents who have shown an ability to act in the best interest of the child. And you will hear it so many times, the best interest of the child. You're going to hear that throughout any type of family law matter that you have. That is controlling, that is the terminology, that is the standard that the courts will always apply. That's what the courts are looking for. That is a critical component of the court analysis, is best interest of the child. So the court is looking, when you come before the court and you're bringing your custody dispute, the court is looking to see which of the parents, or if both of the parents preferably, are acting in the best interest of the child. And things that are considered in the best interest of the child are the parents communicating properly? Okay, are they behaving properly towards each other and towards the child? Are they getting along? And are they taking care of the child? Are they taking steps to make sure that the child is receiving the care and the necessities, and that the child's needs are being addressed? So those are some of the things the court is looking to see and looking to hear in determining custody issues. Another part of the public policy of the state is to provide a safe, stable, and nonviolent environment for the child. Ideally, both parents will have that type of environment for the child, so that whether they're with the mom or the dad, they're in that same safe, stable, and nonviolent environment. The third part of the public policy for the state of Texas is to encourage the parents to share in the rights and the duties of raising the child after the parents have separated or divorced. So you want to make sure, again, that both parents are working together and that they're both putting in time and effort and resources to help raise the child, hopefully the same way they were doing when they were together and they were married. The next section of my outline talks about different definitions, just again to give you some knowledge of the terminology, the legal terminology that is used in custody issues. So we've got the word custody, which is basically conservatorship. And so you'll hear that a lot. You'll hear conservatorship. You will hear it in court. You will see it in the pleadings. And what it basically means is custody. Those two words are interchangeable. It describes the relationship with your child once a court order is in place. So conservatorship only applies if there's a court order. If there's no court order, there's nothing for the court to enforce. So the court really has no role in your relationship with the child. You're only going to get a conservatorship or a court order if you file some type of pleading with the court, if you file some type of action with the court, or if a third party gets involved, such as child protection services, if they get involved and they have to file something in court to get a court order to remove the child from where they are to protect the child for the child's safety, then you get into the issue of conservatorship and in custody, and then you get your court order. A person who has a court order custody is called a conservator, and there's three types of conservator. And the reason I'm sort of trying to focus on this a little bit and make it clear is that conservatorship is the terminology that is used in Texas for custody cases, which is very, very different from guardianship cases, which is handled by the probate courts, which is a different forum, it's a different court, and it's a different type of case. So when you're dealing with children in Texas and you're dealing with family law matters, it's called conservatorship. Other states use the word conservatorship interchangeably with guardianship, but not in Texas. And so that's why I'm trying to make that distinction and be very clear about when someone talks about conservatorship, they're talking about a family law matter or a custody matter in the state of Texas. There's three types of conservators. You can have a joint managing conservator, you can have a sole conservator, and you can have a possessory conservator. So a joint managing conservator is the presumption. It's generally what the court hopes to do is to appoint both parents as the joint managing conservator, and one of those parents who is a joint managing conservator is going to have the legal right to determine the exclusive right to determine the residence of the child. And that is called the custodial parent. And then the other parent who is a joint managing conservator is the non-custodial parent. You can have a sole managing conservator. And a lot of times you'll see that situation occur when there's some type of violence or abuse that has occurred in the relationship or in the family. And in order to protect the child, the court will make one parent the sole managing conservator. If there's, say, substance abuse, alcohol or drug abuse, or there's the absence of one of the parents in the child's life, that those are other grounds or reasons that a court would determine a sole managing conservator needs to be created. Now, the third type of conservator is a possessory conservator, which I referred to earlier. It's just what its name describes. The possessory conservator is the person who has possession of the child. So if you have a non-parent, let's say a grandparent or a foster parent, who has been named the sole managing conservator, then both of the biological parents would be possessory conservators. So they still have rights as a parent, but they won't have a final say on most decisions that affect the child. Those decisions will be made by the sole managing conservator. So the next important part of custody issues is the possession order. And you can have different types of possession orders depending on what the facts of your case are and what your circumstances are. So there's 4 types of possession orders in Texas. There's a standard possession order, which most people have. There's a modified possession order. There's a possession order for children under the age of 3 years. And there's a supervised possession order. So a standard possession order is basically the parents agree to visitation. They're not fighting over who has the child and when the other parent has the child. And so you can do the standard possession order and each parent gets to see the child whenever the parents agree because they're communicating, they're amicable with each other and with the children, and everything is going smoothly. If the parents have a standard possession order, but they don't agree on visitation times, then according to the terms of the standard possession order, it sets forth a schedule that is required to be followed by both of the parents. And the schedule depends on where the parents live in relationship to each other and the child. So if the non-custodial parent has the right, if the non-custodial parent lives within 100 miles of each other, then that non-custodial parent will have the right to possession on the first, third, and fifth weekends of every month. And then on Thursday evenings during the school year. They'll alternate holidays and they'll get 30 days during the summer vacation period. If the non-custodial parent lives more than 100 miles from the custodial parent, then the weekend schedule can be the same, or it can be reduced to 1 weekend per month. There's no midweek visits, so you're not going to have the Thursday visits. Holidays are the same. You're going to alternate holidays. And then the non-custodial parent has a longer period of time with the child during summer vacation. They have 42 days instead of 30 days. And in addition, they have every spring break. So that's to facilitate the child spending time with the non-custodial parent. I've put links, I've prepared an outline, and I've put links in the outline to a standard possession order so you can get an idea of what it looks like. And it's a form that you can use and fill out if you want to do this yourself, if you want to try to handle this yourself. And you can get the other parent to agree to a standard possession order, then the two of you can fill it out, check the blanks, check the boxes, fill in the blanks, sign it, and file it in your court case, and the court will consider it. There's also a standard visitation calendar, and I've attached links to that in the outline as well. Now, whenever you're dealing with a family law matter, generally the courts have what's called a standing order. And whenever you file some type of a petition and you have to serve the petition on the other party, you're supposed to attach a copy of the court's standing order to your petition, whatever type of petition it is, whether it's a petition for divorce, whether it's a petition for custody, child support, modification, enforcement, whatever it is, you're supposed to attach that standing order. And when you serve your pleading on the other party, you're supposed to have that standing order attached to your pleading and serve it with your pleading. And so I've attached links in my outline to the standing orders for Dallas County Family Courts, Denton County Family Courts, and also for Tarrant Family Courts. I had a little bit of difficulty finding the standing order for Tarrant County Family Courts. So what I linked to was the website for all of the different courts. And so you have to, depending on where your case is filed, look at that particular court's standing order and how they handle that particular issue. If you don't want to use the standard order, possession order, let's say that doesn't work for you, or you're not happy with it, or there's some reason, whatever the reason may be, that you want to make changes to the standard possession order, you can do a modified possession order. And there's 4 different types of modified possession orders that are included in my outline that I've linked to. You can do alternating weeks. So the child could be with one parent for 1 week and then spend the second week with the other parent, then the third week with the first parent, then the fourth week with the other parent, and back and forth like that. So that's one option. Another option is splitting weeks and alternating weekends. A third option is day visits and no overnights. And then a fourth option is the non-parent is the managing conservator. So those are give you some ideas of options that you have in crafting a possession order, depending on your circumstances and depending on the needs of the child, and depending on the location and the circumstances of the parents. There is a possession order that is specifically designed for children under 3. So the legal presumption in Texas is that the standard possession order is in the best interest of a child who is over the age of 3. But when a child is younger than 3 years old, that legal presumption doesn't apply. So if your child is under 3, the other parent can agree to use the standard possession order, or you can tailor a possession order that specifically fits your situation. And the reason you would want to do that is because children who are 3 years old or younger tend to be very, very attached emotionally, mentally, they're just really, really attached to their caregiver, whoever their caregiver is. And so whoever's providing the lion's share of care for the child, that's who the child has a stronger bond with, or a closer bond with. And so for that reason, you may want to make sure that the child, if they're under 3, still has a significant amount of time with that particular caregiver. The other thing is you're going to have to balance your visits based on the schedules of each parent and whose schedule is more flexible, whose work schedule is more flexible, who has more time on the weekends, who has more time during the weekday, who can take the child to the doctor. It's been my personal experience, having raised 4 kids, that children under 3, they tend to get sick a lot, just because if they're in daycare or preschool, or even in a family type setting where they're around other small children, past germs, and they just tend to get ear infections, throat infections, tummy issues, and they need to go to the doctor quite often. So somebody has to have a really flexible schedule to be able to take that child for medical care and attention. So those are some of the options you want to consider. If there's a situation where there, like I talked about earlier, where there's some type of violence or substance abuse or neglect or absenteeism, you may want to consider a supervised possession order. And in that case, that's a situation where either one or both parents or the judge is concerned about the child's safety just because of the environment that the child is in and because of the behavior of the parents. So the judge can order that a parent's time with the child is supervised. And if that's the case, then the parent whose time is supervised, they have to comply with that court order. So the other option is that the judge could order their no visitation rights for the particular parent who is having difficulty in their life at this particular time. So the option is used when the visiting parent, even with the supervision, would be physically or emotionally harmful to the child. So it's important to talk to a lawyer and find out, again, what's in the best interest of the child and how it's affecting the child, and craft your order based on the facts of your particular case. In terms of custody, it's important to understand that joint custody does not mean equal custody. Mothers and fathers do have the same rights under the law, but that does not mean they have the same amount of time with the child. So right now, the split is about 75-25. So whoever is the custodial parent, that's the person who usually winds up with spending about 75% with the child, and the non-custodial parent usually winds up spending about 25% of time with the child. But later on, I'll talk about how there's a movement to change that balance. And there's legislation right now before the Texas legislature to try to create a 50-50 split of time, a more balanced time with both parents, so that basically fathers get to spend more time with their child if they're not the custodial parent. Again, we have the children under 3 years of age issue. And so whoever decides to be the primary custodian should be able to devote the necessary attention and time to the child to support their growth. And that's really important, dropping them off at daycare, picking them up from daycare, doctor's appointments, all those kinds of things, social activities, other physical activities for their health and growth and welfare. So what happens when one of the parents is violating the custody order? And that's where usually the attorneys get involved, because you've got some acrimony or some, conduct here that is inappropriate or is non-compliant with what the court has already ordered. So if the other parent is not complying with the current possession order, so let's say they're not picking the child up when they're supposed to pick the child up, and it's causing the child emotional problems, or let's say they're not returning the child when they're supposed to be returning the child, and it's causing the custodial parent to have scheduling issues and just disruptive to their schedule. Probably the best thing to do is to start documenting. And when I say documenting, what I mean is make a ledger, make a notebook. Just get a notebook and start writing down the dates and the times of the incidents when they happen and describe exactly what happened. You don't want to rely on your memory. You want to make very detailed, copious notes of exactly what's going on and when it's going on. So if they were supposed to bring the child back on a Sunday and they didn't bring the child back until Tuesday, and they didn't tell you, you didn't know if the child was going to school or not, you didn't know what was going on, that's just an example of a situation that could occur. Start keeping, stay calm. First of all, stay calm as you can. Make sure your child is safe, and try your best to continue to communicate with the other parent in as calm a manner and as respectful a manner as possible. That's always going to be the better option. And if you see that this is an ongoing problem, despite your communications, despite your request, despite trying to get along with the other parent, then you're in a situation where you do want to seek legal advice and you do want to go back to court and try to either modify the custody order, or if you're happy with it and you don't want to change it and you just want the other parent to comply with it, then you're looking at an enforcement order. You're looking at trying to get the court to assist you in enforcing the current possession order that's in place. But you definitely want to consider if this is an ongoing problem and you see that your best efforts are not changing anything, and it's not the other parent is not coming around and they're continuing to be obstructive and disruptive, then you definitely want to seek relief from a judge. So some of the actions you can take is you can file a motion for a writ of attachment and get a court order ordering the non-custodial parent to return the child to you. And that is something that the police can assist with if you have that type of court order. You can file a petition for habeas corpus. It's the same thing. It's a writ, and you'll get a court order again saying that the non-custodial parent or whoever has the child has to return the child to you. You can file a petition for enforcement of the current custody order, saying that the parent is violating it because they have the child when they're not supposed to. It's your time that you're supposed to have the child, so they're keeping the child from spending the allotted amount of time you're supposed to have. And you can file a request for a warrant to take physical custody of the child. Should you try to take the child back yourself? Well, that's a very, very difficult question to answer. And unless you know for 100% certainty that the child is in some type of immediate danger, I don't think it's the best option to try to go in yourself to the other parent's home or to their employment or wherever they are and try to take the child back. I think the best thing to try to do is, again, communicate with the parent in a very calm manner. If that's not working, consult with an attorney. Unless you have a court order, it's unlikely that the police are going to take some action to try to help you. So you definitely want to already have your, whether it's a standard possession order or modified, you want to have that order in place and make sure that you have a certified copy of it, so that if in the case you do need to get the police to assist you, you do have that order to show them. And if they don't assist you with even this possession order, that's when you need to go back to court to get something more, such as one of the other petitions that I've talked about. So you definitely want to consult with an attorney, and you definitely want to stay as calm and peaceable as possible, if not for any other reason, for the child's sake. So I'm going to skip over, there's a section in my outline that talks about child abduction, but I'm going to skip over that because I think there's some more other important parts of the outline I'd like to touch on. And one of them is parental alienation. So what do you do if you have a parent who's trying to alienate the children for you, telling the child things like your mom doesn't love you, your mom prefers, her significant other, she's not spending as much time with you, she wants to be free with you, just really saying really bad things about you and hurting the child emotionally, and just basically driving a wedge, putting suspicions in the child's mind about you, and you're noticing that it's having an effect on your relationship with the child. What can you do? Again, just, try to remain calm. Make sure you're doing what you're supposed to do. So make sure you're showing up at all of the child's activities. Whenever the child needs something, make sure you're there. And just keep doing what you're responsible for doing, despite what the other parent is saying. And the child will see that, well, my dad, he always picks me up on time. He always brings me back on time. He's always at my school events. He always makes sure he's there for my birthday, for holidays, for Christmas, whatever. Your behavior, your actions are going to speak louder than any words that the other parent is saying against you. And there are some places, and I do have some places in my outline that you can go to for help with trying to get in assistance with this type of behavior from the other parent. Counseling is a great idea for yourself, for your child. That's something I always recommend to my clients, particularly when they come to me and they are requesting divorce or they have custody issues, because these issues are so emotionally charged. And as adults, we struggle with these type of issues, and children struggle even more with them. So counseling, whether it's through your church, whether it's through your health insurance, it's always a great idea to have that support and that network to speak to someone, to work through your feelings and go through that whole process of healing, because it is a process and it does take time. And I don't want to get off on a tangent too much on that, but I strongly feel that that's really critical and important when you're going through such a major life change that affects everyone around you. It affects your children. It affects your other family members. It's just very, very dramatic. And so it's really helpful if you can get some type of counseling or support services to assist you while you're going through such a significant life change. So I want to go to talk about the legal procedure to obtain a custody order. So it's like, okay, so I've got this child and I really need to get a custody order in place because, we need some structure in terms of when I'm seeing the child and when the other parent is seeing the child, because what we have going on right now is not working. So what do I do to get a custody order? Okay, so again, you want to educate yourself. There's a great website. It's called texaslawhelp.org. Many people may already be familiar with it. They have forms that are extremely helpful. They have frequently asked questions that give answers to some of the questions you may have. They tell you what the law is. They will direct you to the particular statute so you can read it and find out what the rules are. And again, you want to make sure that you familiarize yourself with whatever court you're in, whether you're in Dallas County, Denton, or Tarrant. Make sure, if you're doing this yourself, that you familiarize yourself with the court's rules, because that's really, really important to make sure procedurally you're following the correct process. So if you want to get custody order, you're going to have to file something with the court, either a petition for divorce or a suit affecting the parent-child relationship. In legal circles, it's called a SAPSR case or SAPSR suit. You're going to maybe even want to file some type of a paternity case to either have paternity terminated, the father's rights terminated, or to have paternity determined. So if there's been no acknowledgement of paternity, and you're trying, maybe you need child support, your child needs financial support, needs child support. So you want to file a petition asking the court to order genetic testing and have the father identified as being the father of this child. If there's some type of family violence or some type of domestic violence going on, you definitely want to file a family violence protective order. So you want to get that in as quickly as possible. And sometimes that can be an ex parte order. And if you file any type of divorce petition or paternity petition or anything like that, you can always file temporary orders in a parenting plan with those pleadings and get that in front of the judge at a hearing very quickly, so that issue can be decided very quickly. So then you have some type of custody order, even if it's temporary, you have it in place to add some structure and to create some boundaries. And so both of the parents know what it is they're supposed to do and what they're not supposed to do. And you can also get injunctive relief as well, some type of temporary restraining order, preliminary injunction, or permanent injunction. You're going to have to get, whatever you file with the court, you're either going to have to get the other parent to waive service. If they won't agree to waive service, then you're going to have to serve them. And you do that through the clerk's office. So you request your service through the clerk's office. The clerk's office will prepare the citation, give it to the constable's office. The constable will go out and serve the pleadings on the other parent, and then file a return with the clerk's office showing proof of service. Once that's done, then you can move forward with your case, setting your hearing, and there's a procedure you have to follow to do that properly. In January of this year, the legislature amended the discovery statutes for family law cases. So now you have to provide required disclosures. So if you file a case on your own, if you're doing this on your own because you can't afford to hire an attorney, you want to make sure that you comply with those required initial disclosures. You have to do it. It's mandatory. And if you don't do it, you're not going to, get forward with your case. So make sure you comply with that. Also, if you don't have enough money to hire an attorney and you don't really have enough money to pay court costs, you can file a statement of inability to pay cost in an appeal bond. And that's a form that you can get at texaslawhelp.org. You can fill it out. It requires you to put in your financial information. You need to be truthful with your information on this form because it is an affidavit and you have to be sworn before a notary. You're taking an oath that you're telling the truth and you're declaring that the information you're putting in is truthful under penalty of perjury. So just make sure that everything you put in that statement of inability to pay is accurate, and that you can back it up with, your pay stubs, your tax returns, that type of thing. And so once you get that filed, you can get an order from the court saying that you're not required to pay court costs in advance. And then you can continue, you can do your service of citation if the other parent won't waive, and it won't cost you anything. And then you can set your temporary orders for hearing. You have to do a notice of hearing, and you have to do that properly, and you have to give the correct amount of time of notice to the other party. And that's really, really important. You want to make sure you dot your I's and cross your T's when that's concerned, because you don't want to get your hearing dismissed, and you don't want to make a bad impression to the court, and you don't want to get in trouble for not doing it correctly. So For setting your notice of hearing, there's a link in the outline that takes you to a form that is a notice of hearing form. You have to make sure you include the date, the time, and the place of the hearing. You should attach, if the other party hasn't waived their service, you want to attach a copy of the pleading to the notice of final hearing. So you want to make sure that they get a copy of whatever it is you filed, whether it's a petition for divorce, whether it's a motion for enforcement, a motion for modification, whatever you filed. Make sure you attach a file stamp copy of it to the notice of hearing, and make sure you send that to the other parent. You can send it by mail, U.S. Postal Service. Make sure you send it certified mail return receipt requested so that you get a signed green card back. If you want to send it by express mail, you can do that too. That's fine. Just make sure you get the post office to attach a green card to it and that the person has to sign for it, so that you get that proof of service back. Because when you attend the hearing, you need to show the proof of service that you actually did serve the other party, because you don't want to get in front of the judge and get into an argument as to whether or not the other person got served and whether or not they got served properly. So you want to have proof of your notice, and that eliminates that issue, so you can focus on the real issue while you're in court, which is either to modify the possession order or to enforce the possession order. If you want to modify your existing order, there are certain grounds that you have to allege in order to get the modification. So first of all, and again, this is a thread that's going to run through the entire case when children are involved, is it in the best interest of the child? So you have to meet that test. Is the modification of the current order in the best interest of the child? In addition to meeting that test, there's several other grounds that you have to show to the court. So does the other parent agree to the modification? Maybe they do. Maybe they're cooperating. That's great if they do. But if they're not, what you're going to have to show to the court is, have the circumstances of the child changed either materially or substantially since the date of the first possession order, or the date that there was some type of collaborative agreement or mediated agreement that was based on the first possession order. Is the child 12 years of age or older? If so, have they expressed to the court who their preference is to be the managing possessory conservator? Who have they said who they want to have the exclusive right to determine their residence? At 12 years of age or older, the law provides that they can tell the court what their preference is, and the court can take that into consideration. Another ground is, has the conservator, who has the exclusive right to designate the primary residence, have they voluntarily relinquished primary care and possession of the child for at least 6 months? Okay, this doesn't apply to someone who's in the military. So if you have a parent who's been deployed by the military, you can't say, well, they voluntarily relinquished their rights of possession and primary care because they're not even in the country. They're in Afghanistan, or they're in Iraq or Iran somewhere fighting a war. This relinquishment for 6 months doesn't apply to military deployment. So you can't use that. So if you meet some of those criteria, then you're going to want to file your petition for modification, file your inability to pay, make sure that you serve the other party. If they won't waive service, make sure you serve them. Once they file their response, make sure you give your initial disclosures, prepare an order for the court to sign. You want to make sure you have an order. And set your hearing. You're going to have to contact the court's docket assistants and get a date for the hearing. Make sure you get it far enough out so that you can give the other party the proper time to appear and give them notice in time for the hearing, and then appear at the hearing and put on your evidence and your testimony, have your witnesses there, and then the court will make its decision. I've just been told that my time is up, but I hope that you get my outline. Again, there's some links in it, and I do talk about the coronavirus and the impact that it has on family law cases. And there's also some frequently asked questions in there. So if you have any questions about custody issues or divorce matters, please feel free to give me a call. Thank you very much for your patience and for listening.
Kathy, thank you so much for that information. We really appreciate it. I would like to address those who may be just getting on now with us and joining us for this session. This session is to provide you with information that will help you support with your child rights and help you get information that will provide you strategies for navigating the court systems and how to make sure that you are well informed and with the ability to see your children and co-parenting in a collaborative way that is most beneficial for the child. So Kathy, we will have a question and answers from the audience at the end of the session, but I do have a couple of questions I would like to ask you. So what should I do as a co-parent if the co-parent that I have my child with is not responding to my request to see our child on our prior agreement?
Okay, so that's going to be a violation of the current custody order. And so if they're not allowing you to have access to the child, again, you're going to want to document what's going on. So document the dates and the times that you were refused access to the child. And if this is a continuous problem, you definitely want to seek the advice of an attorney. You may not need to actually hire an attorney. This may be something you can handle yourself, but I would definitely advise you to at least consult with an attorney about what's going on if this is a recurring problem. And then you're looking at going to court to file an enforcement order. So you're going to want to file a motion or a petition with the court, asking the court to enforce the custody order that's in place because the other parent is not allowing you access to your child.
Okay. What should I do if my co-parent, is taking my children around people who may be a negative influence to them?
That's, again, a violation of the custody order because there's usually language in there. And again, it's a violation of the best interest of the child. If they're taking the child around people who, are behaving in such a way that it's having a negative impact on the child, or they have the child in an environment that's not a safe, stable, healthy environment, you're looking at either enforcing the current custody order, or you're looking at modifying it to either limit the other parent's visitation rights, or creating a supervised possessory order where the other parent can only see the child under supervision. Or in the worst case scenario, depending on the facts of the case, the judge may say no visits for you until you get your act together. So you're looking at going back to court to have some change in the current custody order.
One more question. So,
okay.
How should I prepare a suit against my co-parent for child custody rights?
Okay, so that's a petition for either it sounds like a petition for enforcement or a petition to obtain a custody order. And you're going to want to file that when you file either a divorce petition or paternity petition. You can go to texaslawhelp.org, and they have forms on their website. And they're very easy to read. They're very easy to understand. They have check boxes and they have blanks that you can fill in. And so it depends on what type of case you're filing, where you're trying to actually obtain a custody order. And I refer to that in my outline. So it could be a divorce that's uncontested with minor children. It could be a contested divorce with minor children. It could be an unmarried person who has children with someone. It could be an acknowledgement issue where you're trying to get the other parent to acknowledge paternity. It could be paternity testing. There's different circumstances that occur. So you're going to have to look at the forms that are at that website and see which one best fits your case. And again, you also may want to consult with an attorney to find out how to draft and craft that motion or that petition.
Kathy, thank you so much for that information. For those of you who are interested in the outline that Kathy mentioned, that will be on the Friendship West website within the next several days. So please go out there and check it periodically to get the information that you're looking for. Next up, we have Mrs. Wendy Wilkerson. Wendy Wilkerson is a senior counsel for Texas Instrument. Wendy is also the the managing supervisor for the Dallas Volunteer Attorney Program at the Friendship West location. So please join me in welcoming Wendy Wilkerson.
Oh, thank you so much, Carlos, for that gracious introduction. I do have a set of slides here, and if you're not able to pull those up, I can share my screen.
Yes, please share your screen.
Okay. Okay. Let's get that in slide view. Okay, can everyone see the screen? Just I want to confirm before I get started.
Yes, we can see it.
Okay, great. So thank you, Kathy, for that really good overview. I learned some things myself, so thank you for that. The topic that I will cover today is Texas Child Protective Services, so understanding and navigating the process. Before we dive into our topic, there are a few housekeeping items I want to make sure that I highlight. The first is that all the content for this presentation was pulled from the Texas Department of Family and Protective Services website, which is located at www.dfps.state.tx.us. This will also be available on my resources page, but just want to make sure that our audience is aware of the comprehensive website that's out there that can help answer any questions that may not be addressed today. The second item is, although I am a practicing attorney, what our discussion will cover today should no way be viewed as legal advice or guidance. And finally, I am employed by Texas Instruments, but again, our discussion does not represent any position or opinions of Texas Instruments. So with that, let's just jump into our topic. So we have an agenda for today. We're going to start off with an overview of the Texas Department of Family and Protective Services. I think it's really helpful to understand how Child Protective Services and Child Protective Investigations interact with or are related to the Texas Department of Family and Protective Services. We'll then go over the intersection between CPS and child custody matters to understand when will CPS get involved in a situation. We'll walk through investigations. I've highlighted a few key takeaways, and then we'll close out with our resources page. Okay, let's start with our overview and structure. So we have, of course, the Texas Department of Family and Protective Services, also known as DFPS. What their goal is, of course, is to work with communities to promote safe and healthy families, and also to protect children and vulnerable adults from abuse, neglect, and exploitation. So DFPS has 5 major programs or divisions, but for purposes of our discussion today, we will focus in on 2, Child Protective Services and then Child Protective Investigations. Again, so you may hear terms like, well, I have a DFPS investigation. That still involves or entails Child Protective Services and Child Protective Investigations. DFPS is the umbrella, if you will, with these other programs under it. The core mission of Child Protective Services, or CPS, is to protect children. through a collaborative effort with communities, service providers, and families. So it's always good to understand and know what is the objective here of CPS? What is that core mission? What are they trying to achieve? And I think it's helpful for us to understand, what that is. So the intersection between CPS and child custody matters. When will CPS get involved? So generally, CPS becomes involved with children and families when they are referred by the DFPS investigation unit, which is Child Protective Investigations, or also known as CPI. Well, how does CPI get a referral? There's been a reporting of child abuse or neglect. So that's how an investigation could potentially trigger, is when there's been a report of child abuse or neglect. Well, who can make that report? State law requires anyone who suspects child abuse or neglect to report those suspicions to DFPS or a law enforcement agency. So when we say anyone, that can be a family member, it could be a teacher, it could be a social worker. What has to be within that report? Specific information, okay? You have to have within that report the alleged victim's address and an allegation that indicates abuse or neglect as defined by the Texas Family Code. So a few examples of abuse or neglect: one, mental or emotional injury to a child that results in the material impairment to that child's development, or a failure to make reasonable efforts to prevent an action by another person that results in the physical harm to a child. So the point here is that it can't just be a frivolous report. It has to have information, concrete information within that report. It has to have a victim's name, address. It has to have a specific allegation of what is happening with that particular child. Once that comes in, CPS will examine the reports of child abuse or neglect, and then it's up to the investigators to decide if there are any threats to the safety of all children in the home. So let's dive into the investigations. What does that look like? So conducting the investigations, what are the investigators looking for and what tools are they using? Now, I want to point out, this is not an exhaustive list. This is just a few examples of what an investigator may do and what that investigation is comprised of. So an investigator may interview the child who's been abused or neglected. If that is a tool that they choose to use, that interview with the child must be audio or videotaped. The interview may be held at any reasonable time and place, so this includes school. The investigator may interview family members, teachers, anyone with knowledge to get enough information for the investigator to make a determination if there's a safety threat. Investigators will make a reasonable effort to tell parents about any interviews that have taken place and the nature of the report, typically 24 hours after an interview. Investigators may request access to mental health records on your child, yourself, or people alleged to have abused or neglected the child. It may entail a visit to the child's home. Investigations typically are completed in 30 days. So what happens at the end of that investigation? What are some potential rulings that can take place? Well, on the website, DFPS outlined 5 potential dispositions or rulings that may be attached to an investigation. 1, reason to believe, that is abuse or neglect occurred based on a preponderance of evidence, meaning it is more likely than not that abuse or neglect has occurred. A second disposition, ruled out, that is that the staff determines it is reasonable to conclude that abuse or neglect has not occurred. So just because an investigation has started and you've gone through the process, it doesn't necessarily mean that there will be something more beyond that. It could very well mean once an investigator has had opportunity to understand what the circumstances are, they've conducted their interviews, they may very well conclude that abuse or neglect has not occurred, and then that ends there. The third disposition, unable to complete. This is a circumstance where the investigation cannot be concluded, typically because the family could not be located or the family refused to cooperate with the investigation. A fourth potential disposition, unable to determine. That is the conclusion that none of the dispositions above are appropriate. And then finally, administrative closure. That is a ruling that DFPS intervention is unwarranted based on information that comes to light after the case is assigned for investigation. So again, these are the 5 potential dispositions of an investigation. Okay, so now at the conclusion of an investigation, there are 2 potential outcomes. The first, investigators can conclude that children are safe because no abuse or neglect is discovered or have been identified in the current investigation, or the family appears willing and able by using family resources or community resources to deal with any potential safety threats and risk factors in the child's life to ensure the safety of the child. So that's one situation, conclusion that the children are safe. The second potential outcome, investigators conclude that the children are unsafe. So the investigator finds after conducting interviews that there are significant safety threats, and the family appears unwilling or unable to use family and community resources to manage those safety, potential safety and risk factors. So if the investigator concludes that the children are unsafe, the investigator may offer services to address the problem. They may refer the case for family-based safety services, or, and I guess in a more extreme fashion, may file a petition to initiate civil court actions to protect the victim. And these court actions could include the removal of the child from the home and possibly ending parental rights. So here are a few things to keep in mind when investigations are being conducted. The first is investigators do not make these decisions alone. These are very important decisions, so they're not being made alone. Investigators, supervisors must approve these decisions, so there is some oversight. The second item, should parents disagree with the findings or even the conduct of an investigator, parents have a few options. They can speak to the investigator, or they can speak to the investigator's supervisor. There's also an option to request an administrative review of the investigation. Now, this administrative review of the investigation can happen unless a court has upheld the findings. So if there's a situation where there's a court case involved and the court has made a certain determination, then that administrative review is not an option. And finally, if there are really grave concerns about the conduct of an investigator, parents may reach out to the DFPS division, their consumer relations division, and the email is listed out here in this slide, and will also be is also available on the Department of Family and Protective Services website. The last item I want to make sure that I highlight: parents have the right to consult with an attorney at any point in the investigation. DFPS employees are prohibited by law from giving legal advice. So what that means is you should not look to your investigator or any other employee of DFPS to provide you any legal advice. If there are questions that you have about the investigation, or you feel that you need an attorney, there are resources out there for you to reach out and connect and potentially engage an attorney. And I have that website for legal aid in Northwest Texas. That's in our resources page that we'll get to. Okay, post-investigation. What are some potential paths for parents, and how will Child Protective Services now get engaged? So as I mentioned earlier, before you get to the child protective investigations, there first has to be a report, right? Then you have the report. Then after the report, you have the child protective investigations that will go through and investigate. And we just went through all of that, like what that investigation entails. So after the investigation, one of the options, of course, is that Child Protective Investigations will then refer it to their case to Child Protective Services. Now Child Protective Services picks up the reins and starts thinking through, well, what makes sense now that we've gone through the investigation, what may make sense for this particular family, this particular child. So there are a few options here. Let's just say options, a few paths. First, the family-based safety services. This program is designed to maintain children safely in their homes or just make it possible for children to return home. So this will come into play when a child's safety can be reasonably assured. CPS provides in-home services to help the child stay in the home, or while the child is in the home, will kind of provide those services to the parent to help kind of stabilize what's happening in the home. Or children may live elsewhere temporarily, usually with relatives or close family friends as they're going through this process. Now, these services may include, but are not limited to, family counseling, crisis intervention, potentially daycare. A second path, the family group decision making. Now, this describes a variety of practices to work with and engage children and their families in safety and service planning, as well as decision making. So this includes the use of family team meetings, for example. That typically happens when the child is in the home. Or you may have a family group conference. This is when will get triggered when the children have been removed from the home. But the bottom line is, this is a collaborative effort to work with the family and that child to make sure that the child's promoting the stability of the child's home environment. Because again, we want to focus on what is the mission here, what is the objective, and that's to ensure that the child is protected and safe. Finally, the last potential path are parenting classes. CPS may recommend parents attend parenting classes, and these cover a range of topics. Teach parents, for example, the basics of child development, so they will have appropriate expectations. Help parents recognize their strengths, connect parents with other parents for support and encouragement, because sometimes that's what's needed when you find yourself in a challenging time, with your children, with the family. Sometimes you just may need an encouraging word. You may need to just connect with other individuals who can offer that support. And so this is one of the layers of Child Protective Services that may be accessible or available. So a few key takeaways. We talked through a lot, so I think it's always helpful to kind of go back through, what are some of the highlights? What are things that I should walk away and remember from this discussion? The first, Child Protective Services and Child Protective Investigations are both divisions/programs under the Texas Department of Family Protective Services. So when you hear things thrown out there, DFPS, just remember, okay, that includes CPS, that includes CPI. So they're all connected. Second, reports of allegations of abuse or neglect. That's what will generally trigger a potential investigation by CPI. This is not just going to come out of nowhere. There's someone out there who thinks that a child could be in danger, whether it's the child is being neglected or the child is being abused. The length of investigations normally lasts about 30 days, and parents have a right to consult an attorney at any point of the investigation. If parents disagree with findings or the conduct of an investigator, there are options for the parents to speak to the investigator, speak to the investigator's supervisor. Also an option for parents to contact the DFPS Consumer Relations Office. Depending on the outcome of the investigation and the investigator's findings, that's when CPS will get involved to offer, and again, it's based on the circumstances, potential paths to resolutions. A lot of this is always going to be fact specific. It just really depends on what the circumstances are, and also depends on how cooperative all of the parties are involved in terms of getting to a solution that best addresses what those circumstances may be. And finally, it can be a challenging situation, but DFPS encourages a collaborative effort between families, service providers, communities, overall, with a goal of protecting the safety and well-being of our children. So I want to end with our resources page, just to remind all, where you can find information. I want to emphasize that all the information that I shared in the previous slides that we've gone through was found on the Texas Department of Family Protective Services website. Again, a really helpful resource. There are also links on that website to other potential resources, so it could be really helpful. And then the second website I want to flag is the Legal Aid of Northwest Texas. I mentioned a few times how during this process of a CPI, Child Protective Investigation, you can consult an attorney. And so obviously, attorneys can be expensive. So Legal Aid of Northwest Texas has a wonderful program where you may be able to secure an attorney at little to no cost. And you can find out more information at the website, the Legal Aid of Northwest Texas. And so with that, that is my last slide. And if there are any questions, happy to answer.
Winnie, thank you so much for that enlightening information. Actually, I do have a couple of questions I want to ask you. If a child is taken away from their parents, does that mean that the parents are unable to get the child back?
There are obviously, it all depends on the circumstances involved, but there are always options for the parents to work with DFPS to pull together a path that makes sense. I mean, DFPS only removes children from a home when it is necessary to protect that child from abuse or neglect. And this is probably a more extreme case because it only happens when there are no other reasonable efforts that will keep the children safe. But are there paths to addressing that? Yes, there are. And again, I can refer back to the website, which outlines, and then also within our presentation that outlines some potential paths to resolution.
Okay. But is there a process for close family members, such as a grandparent, an aunt, or an uncle, to gain custody of a child that's been placed in the system? And if so, what is that process?
Okay. So when DFPS removes children, at that time it will request from the parents, or it will request that the parents complete what's called a child caregiver resource form. This form gives DFPS the names of at least 3 people that including, grandparents and other relatives, adult relatives who might be able to provide emotional support or other support while parents receive services. So there is an option out there. It's just making sure that individuals complete the correct forms. And those forms are actually available. You can see what those forms look like on the DFPS website.
Okay, thank you very much. Our next attorney is Kirk McCraw. Mr. Kirk McCraw is the chairman of the board for Mothers and Fathers for Equal Rights. Mothers and Fathers for Equal Rights is the original first and largest mothers and fathers group in North America, serving families primarily in Texas with a referral network of counselors and family law attorneys to promote consistent strategies for what is the best interest of the child. Please welcome Mr. McCraw.
Tell him unmute his mic.
Mr. McCraw, I believe your mic is on mute.
Okay, can you hear me now?
Yes, I can. Thank you.
Awesome. Thank you for inviting me. I'm pleased to be a part of this. I'm the chairman of the board of Fathers and Mothers for Equal Rights. We've changed our names from fathers to include mothers now. For 46 years, we've been allowing the lay people that are not attorneys, maybe possibly can't afford an attorney, the introduction to how family law is viewed, what the protocols, what the procedures, what their guidelines, what they're looking for, basically to understand how to navigate. Most people in divorce, especially when they're interacting with the divorce itself, or actually finding themselves introduced to somebody like CPS or a CPS investigator, understand mostly how they're being perceived in the real time of the way they're interacting with people. They're under stress, they're scared, they're angry. and they react or respond in a way that actually causes them as many issues. I call them blind spots. Most people don't realize what's behind them, and they back right over something that they really cared about. And so we allow people to get a understanding actually of, if you will, what to do and mostly what not to do. We have volunteer attorneys that will come in and speak with people on their cases, help them to understand what the protocols and procedures are, what you would do next to gain custody or get your custody when you have an ongoing divorce, when you're kept from your child, from the other parent, if you will. How to deal with issues surrounding CPS. Most people don't understand that they have certain rights and that their children's rights are upheld through their rights. And so it's important to speak to an attorney, and most people that we meet on our level mostly can't afford an attorney or haven't been introduced to one in a way that they see as a viable option. And so many times, if you've even hired an attorney, they charge more than we do. The hourly rate is so astronomical that the attorney can't afford or charge them to inform them on how to help that attorney. We can help you understand what evidence is and what evidence is a waste of time. We can help you to show that attorney a way that would introduce that evidence for that attorney, that he doesn't have the time or the resources to go and connect all the dots to make it admissible. Most of court and most of litigation, if you will, is based on fact and the fact of the evidence. And the evidence has to be introduced in a way that's acceptable for the court to call credible. So we help in a lot of issues that people don't even realize they need awarenesses of, issues on. We are often referred to from someplace similar to CPS or CPS themselves, sometimes judges or clerks at the courthouse, other attorneys. A lot of our referrals do come from legal aid because people don't qualify for legal aid for whatever reason. And so we are the resource that people come to generally, although we're not legal aid. Our membership is an annual thing. It's after 46 years, we have to charge something. It's $350 for 1 year's membership. For that, you can come to our office any day you want to, without an appointment, anytime you need to. Speak to one of our staff or one of us, or even one of our attorneys, and they will allow you the opportunity to, we'll assess where you are, how you got there. We'll address what you want to do, what you think the perfect resolution would be to that. And then we'll allow you a bird's eye view on how you can prove that in court, or if you had admissible evidence in court, or if it's an option, or if it's a good option and a viable option, we'll give you a possible strategy, a solution, point you in a direction that would help you connect the dots for either your attorney or even represent yourself. Most people that come to us end up at some point exhausting their resources to the point that they need to represent themselves, pro se it's called. And to do that, you have to have certain documents and introduce motions, petitions, other things in the court. We can help with those resources and put those in your hand and show you basically how to follow them yourself, get court dates, serve the other party, and actually represent your case with what I would call admissible evidence. Basically allow people to go 2 steps forward without necessarily always going 2-3 steps back. If you have a good case, you'll understand what that is. And if you don't, you might understand that it's time to try to resolve something. Most parents are in a power struggle, and they're so self-involved they don't realize what they're doing to their child. I, as the chairman of the board, have been through this. And I'm to the point where I tell people, I know that you're our member, but I don't care as much about you or your spouse or ex-spouse. What we're trying to do is resolve this so that you're aware of exactly who's in the middle and what the perception of that is, and so that you can settle this in your child's best interest, because that's the only thing the court really concerns themselves most of the time, especially with CPS, high conflict divorces. We have two parents that cannot resolve something, and they've got their kids in the middle of something as if it's the goal line or the football that they're trying to make it past go with. And we really try to discourage that to where we can get people to mediate the best way, the best outcome to any issues, be it CPS, be it the divorce, be it trying to continue custody in your post-divorce, child support issues, all those things. The best way to do that is to free the court up and mediate these things to the best interest of everybody, because you do not really want a judge or a third party, if you will, to decide exactly what's going to happen in your life. And so that's mostly what we try to gain awareness of. And that's the most helpful opening up and beginning of awarenesses of how people are being perceived by the courts, by the other side, if you will. The judge is there, he does this all day long, and everybody in his courtroom comes in putting on their best dress and their best speech and their best evidence, if you will. And he really can't afford to believe you over this person or that person over the other. He has never met you before, and you may be very convincing, but you have a motive of gaining something, as in custody of your child or something else. And so knowing that you have a motive, he looks for outside evidence. He looks for outside guidance of somebody to corroborate one side or the other and bring more sense to a situation. It's civil law. It's not black or white. It's not good or bad. It's not guilty or not guilty. It's what's in the best outcome with this terrible situation in this moment. And he has to make a choice on exactly what is the best outcome. Most of the time, it's not a perfect outcome, especially for either parent. That's why you want to settle this out of court. But when you do go to court, you need to understand what it's about. You want to really perceive the way that you think is the right way, or the perception being it's in the best interest of the child, not I want to win or get even, which most or a lot of high conflict divorces are about. And so we've been around for 46 years. My favorite line on the telephone is, we don't talk about your case on the phone. We want to get you in our office. But you need to understand what you don't understand. The court system, although uses the English language, they use a bunch of procedures and some words that people just don't comprehend the right way. And the word means something on the normal interaction circuit, but when you get into court, it means something in a certain way that you just really don't understand the direction that you're going in. That's not helpful. And so the first thing we try to do is find out where you are, how you got there, and then really what it is that you're after. And then if that's rational, if it's good for the child, if you will, we'll let you understand that in a way that you can understand it. But we don't usually tell people what they want to hear. We end up telling people what they need to hear. And we get people who don't resolve things very well. And you know, divorces are because people can't stay together. We just don't have the same values. Doesn't mean your values are wrong, but you have to understand the courts are trying to make the best of whatever situation is in this train wreck, if you will. And so that's what Mothers and Fathers for Equal Rights are about. We get many referrals from the outside sources, as in the courts and CPS and things. We are the oldest and largest nonprofit organization in the United States. We're the first ones that ever helped anybody represent themselves and get custody of their children. 46 years ago, there was not a real apparatus or belief system that dads could have rights. Moms always got the children. And there were times when she was mentally unstable or whatever, and she could come out of a bad situation, possibly a mental health institution after a couple of years, and end up with the children in her custody within a couple of days, because that's the way they did it. And at the time, a bunch of attorneys got together. They showed us how to represent ourselves because there was no apparatus in the law to change the law. And we brought up the civil rights issues, and we understood what we needed the courts to understand in a way that they started upholding in Texas, the fact that we too could be parents and custodial parents. And back 46 years ago, that was a big deal. It was national news. People in Colorado or California are saying, gee, those people in Texas are giving custody to fathers of little girls, and that was ground shaking. Today, it's normal business. Everybody understands fathers have the same rights as mothers, and now fathers are doing some of the same things to mothers that were unacceptable, and we include everyone. And the whole litigation that where somebody has to be the bad parent or you have to point out their defects and flaws has been amplified through our efforts. And so as a way of trying to make amends of my term here, I'm trying to help both parents and help them to perceive what's in the best interest of the child, which was the focus back in those days. But it has turned into a very expensive litigation situation that can ruin financially, emotionally. It has actually changed who I am, and I hopefully for the better. But I'm here trying to give back after what I saw my grown children that are 20 and 22 now. Get back to what I wished I had done better. And so that's what we're about, in my opinion. But I appreciate the opportunity to speak on it. I'd be more than happy to answer any questions.
Thank you so much, Kirk, for that information. It was greatly appreciated. Before we get to the general questions from the audience, I do have a couple of questions I would like to ask you. Does your organization assist with legal fees?
We do not assist with legal fees. We do not represent pro bono. I can show you how to save legal fees that are exponential compared to hiring an outright lawyer. We can help with legal fees in that way by helping you, if you have an attorney, to understand what their strategies are and provide them with admissible evidence that will help them rather than them try to educate you in what you need to do. So what we do saves money, whether you represent yourself or even if you're represented. We're very helpful to the attorney because we can read paperwork or show you what's going on in these motions or those documents that would cost you money per hour by the attorney. So we do help in a lot of ways, but it's not money out of pocket from our organization, no.
Okay. Thank you for that response. It's greatly appreciated. I would like to ask a question for each speaker. What is the one thing you wish those needing guidance would take away from their interaction with you today? Starting with Kathy.
Oh, okay. I think it's important I think that Mr. McGraw touched on some important points. I think it's important for the people who are listening to this presentation, who are attending it, to understand that the primary controlling factor in divorce, in involving children, any family law matter that involves minor children, the controlling factor is always the best interest of the child. And I think it's difficult for people when you're in the moment of a divorce or a relationship that has soured. People tend to get caught up in their own feelings, in their own emotions, in their own anger. And I think it's critical to take a step back and to look at the big picture, because you don't want all of your mess pouring out onto your children and hurting your children, because eventually you're going to move on, and you're going to get past this situation eventually. And when you look back, you don't want to look back at how badly you hurt your child, and how much your child suffered because you weren't able to get along or work this out better with their parent. So again, I think counseling is of tremendous help. And there are places where you can get counseling on a sliding scale, if you're employed through your health insurance, through your church. And I think that that's critical for all of the parties involved, for the children as well as the adults. So that's my two takeaways. I have two. Remember, best interest of the children is the controlling factor, and get counseling. Because, as adults, we are dealing with a highly emotionally charged situation, and our feelings are very, very much involved. And there's anger, and there's hurt, and there's pain. And you don't want to make your child the weapon. You don't want to, use your child as the weapon to be the outlet for your anger or to be the outlet for your pain. So best interest of the children or the child, and counseling services. That's the two things I hope you take away from this presentation from me.
Thank you, Kathy.
Carlos, my thoughts there, I hope a takeaway is just there's information out there for you, information that can help you understand this process, navigate the process. You just have to know where to find it. There's information out there, and there are also resources out there to help. And I think Kathy hit on a few good things in terms of the counseling aspect, remembering the best interest of the child. And then Kirk, of course, with telling us a little bit more about what resources are out there to help you navigate through this process.
Thank you, Wendy. Kirk, it's on you.
Okay. Can you hear me?
Yeah.
I have 5 children, 13 grandchildren. We had 2 of our high school granddaughters on the couch one day talking to them, and they asked me more questions about how I do what. And my question was, how did divorce affect them, because their parents had been divorced, both of them from different children of ours. It's a generational thing. We write on our children's soul, and we don't understand it. And if I give you any information on a takeaway, I want you to understand the interaction with our 2 grandkids. Both of them sat on the couch, and the takeaway that I had from what they said was, sitting around the lunchroom table from the 1st or the 5th or the 11th grade, every kid sitting at the table on a large percentage had been through a divorce. I'm thinking 70 to 80% of them, at least. And the takeaway that I had was they all say, my mom says this, or my dad doesn't do that, or my dad says this, or my mom doesn't do that. And they all kind of roll their eyes because there's nothing that they can say. They were so powerless to add any strength to the struggle that their friends were going through, and they're just watching them in the strife because they love both their parents. And what they told me made me open my eyes and realize why I wanted to do what I'm doing, is because the other 20%, the 2 other kids out of 10 sitting at the table, they were just waiting their turn, scared to death. I have a 6-year-old granddaughter whose parents are still intact, and now she's just awesome. And her friend 5 doors down the street, parents split up and got a divorce. She called it a divorce. And she looked at her mom and her dad, and she watched her friend going through what she was going through before she had ever started at school. And she said, Mommy, Daddy, I don't ever want to go through that. It's heartbreaking if you can take it out of yourself. People are right fighting in court. You're fighting because I'm right. No, I'm right. It's a blame game. And that's no way to raise our children, even for 5 minutes. That's what I'd like for you to take away.
Thank you all so much for that insight. We do have a couple of questions from the audience, both directed towards Kathy Rue. Kathy, the first question is, if a non-parent needs to register a child for school that is in their household, what steps should be taken to ensure the non-parent is doing things the right way?
Okay, so that should be in the custody order. There should be some provision as to who's going to make decisions about that. But even if it's going to depend on what's in the custody order and what it says. But generally, even if they're the non-custodial parent, they still should have the legal right to fill out the paperwork with the school and provide the school with the information on the child and register the child. If they're actually living in the household with that parent, and they're the non-custodial parent, then you probably need to modify the court order to reflect that change, even if it's just temporary. So if it's because this non-custodial parent lives in a better school district and you want the child to go to that school, you just need to go back to court and say, well, for the school year, or for a certain period of time from August through November, the child is going to temporarily stay with the non-custodial parent, and the non-custodial parent has the authority to register them with the school. But if it's a standard possession order and both of the parents are in agreement, the non-custodial parent or the non-possessory parent should still be able to have the right to take the child to the school. I mean, that's a positive thing. That's a good thing. That's what you want the parents to do and to participate in and to share in. So I don't see why it would be a problem for that particular parent to go to the school. Now, most of the schools are going to require a copy of the custody decree and the possession order. So you may want to have that with you, and bring that to the school so that they can see, and they can assist in terms of who has access to the child and when they have access to the child. But it shouldn't be a problem. And if it is a problem, you definitely want to talk to an attorney to find out, and maybe have them be a liaison on your behalf with the school.
Thank you so much. I have another question for you, Kathy.
Okay.
How do you submit a request for an in-chambers interview with a child that is 14 years old?
You would file a motion with the court, or if you're appearing at the hearing, you can request in court that the court set it for docket, because you're going to have to get the child in court at some time. And so you want an appointment that's going to be, or you want a court appearance that's going to be, that's going to comply as much as possible with the child's schedule. If it's during the summer, it may not be an issue, but if it's during the school year, you'll want something, maybe later in the day or early in the morning so that the child doesn't miss as much school. And then you want the child to be prepared, but you will definitely want to file a motion with the court and set it that the child is going to appear at a certain date and time so that the judge can meet with the child in chambers and express the child's preference or get the child's information as to what their preference is. I see Mr. McCroy shaking his head, so he may want to comment on my answer.
Thank you. Can you hear me?
Yes.
I think it's, in my experience, called a motion to confer with the child. You'll have the motion heard by the court. The judge will decide whether he's going to confer with the child based on that hearing. At that point, he'll set a time and a date for the child to be conferred with. Some counties, I think that give you a third party that is trained really well at bringing the children and finding out the 2 or 5 different issues. I know Denton will talk directly with the courts, but a lot of the courts, or some of the judges, look at it one way and some of them do it another. It starts with a motion to just confer with the child, and at that point, you can bring the child in, but they really don't like it unless you have an appointment after the motion's heard, in my opinion. I'm just not sure that bringing the kids to the courthouse is what they want, immediately especially.
Okay. One more question. What does it normally cost to hire a family lawyer?
Is that question for me?
Yes.
Okay. My understanding is that family law attorneys, generally speaking, they will charge by the hour. Their hourly rate can start at $300 an hour and go more than that. It may start lower, but on the average, you can expect to pay about $300 an hour or more for an attorney. There are some attorneys who offer legal services based on just a particular part of your case. So you don't have to hire the attorney to represent you from the very beginning all the way to the end. You can hire the attorney just to help you with certain tasks. Like earlier, there was a question from someone as to how to prepare a petition to obtain a custody order. So if you wanted to hire an attorney just to assist you with preparing that petition, you could do that and just pay them for that specific service. There are also attorneys who have a mixed fee arrangement where they'll, for some services, they charge an hourly rate. For some services, they charge a fixed fee or a flat fee, no matter how long or how short the process takes. So I think it depends on the individual attorney that you're dealing with, and it's important to call around and get information on different attorneys. See if you can set up a consultation with them for like 15 or 30 minutes to talk to them to see if you have a good rapport with them. If you you think that this is a person that you can trust and that you can work with before you actually sign an attorney-client agreement hiring them, because I think that's important to find someone that you feel comfortable with and that you trust to work with on your case.
Well, thank you very much for responding to that. We would like to conclude today's session. Thank everyone for tuning in today. I hope that you were able to get something from the information that was presented and use it to